now recognizes the gentlelady from Iowa, Dr. Miller-Meeks, for 5 minutes for her questions.
Thank you so much, Chair Palmer, and I thank all our witnesses for being here. As the representative from Iowa, I take seriously our responsibility to protect public health and the environment, while also ensuring that federal policies are fair, clear, and feasible. In Iowa, clean water affects our farmers, our rural communities, our drinking water systems, and our local employers, as well as families. Many of the entities now worried about the circular liability, like water utilities, wastewater facilities, landfills, and farmers who responsibly apply biosolids, did not create PFAS, but could still be swept up in liability scheme that is retroactive, strict, joint, and several. Cost to passive receivers is only one piece of the problem here. We should also explore options that support swift remediation and provide the liability certainty necessary for American industry to focus on solutions that allow them to continue to invest in the U.S. rather than endless courtroom battles. At the same time, we should be encouraging innovation and American ingenuity. Iowa agriculture is already helping lead the way with promising alternatives to PFAS, including soy-based fire suppressants made from soybean meal. These kinds of homegrown solutions can reduce reliance on legacy chemicals, create new markets for farmers, and strengthen our economy without heavy-handed mandates from Washington. Ms. Bodine, your testimony suggests that insignificant or inadvertent contributors may spend more on lawyers and consultants than on actually addressing PFAS contamination. Can you explain how CERCLA's joint and several liability structure incentivizes litigation over cleanup and what that means for small businesses, farmers, and local governments?
Yes, thank you for that question. In the context of, say, an EPA-led cleanup, they're only going to sue large parties. But the statute gives the parties that EPA sues the ability to turn around and sue anyone else who may fall within a category of liability under CERCLA, which is very, very broad. And those people then spend years, I mean, my testimony talks about, 7 years, 9 years, to get out of the cases. And when they finally settle, their piece of the liability might be tiny, but those 7 years of litigation costs will be huge.
Thank you for that. I also, with having Rock Island Arsenal and the Iowa Army Ammunition Plant in my district, I'd like to echo Representative Pfluger's comments regarding military installations. That is, I think, a concern to all of us. And so I won't ask that question. Mr. Falby, from your members' experience, how has the PFAS designation already affected Phase 1 environmental due diligence, financing, and insurance for commercial real estate projects? And what does that mean for redevelopment, housing construction, and job creation in local communities?
Yes, thank you for that question. We've talked a lot about clean water this morning. Everybody is in favor of clean water. Everybody is also, I believe, in favor of brownfield redevelopment. So it's important to be able to redevelop infill properties that are contaminated. And what we're asking for in terms of a circular liability enhanced protection doesn't mean those sites will not get cleaned up. In fact, I think it paves the way for that kind of redevelopment, because the concern is the unlimited circular liability, the fear of having to write a blank check and pay lots of lawyers, right, to litigate circular liability. So I think, Phase 1 environmental site assessments are great. They're just a look. There's no testing involved. It's still an evolving industry, and just simply the fear that PFOS or PFOA may be on a site, not even caused by anything on that site, but maybe by surrounding properties or air deposition or other issues like that, it creates a great degree of uncertainty. And as I said before, the market, investors hate uncertainty. I think brownfield sites are best cleaned up at the state level where you can get closure without that circular liability.
Mr. Meehan, the EPA has issued enforcement discretion guidance stating it will not pursue certain categories of passive or public service entities, such as water utilities and wastewater systems. Why does this guidance fail to provide real certainty for those entities, and why is congressional action necessary to protect them from third-party lawsuits?
I'll get it right eventually. I'll echo our colleague Susan Bodine that guidance like that applies only to the agency, not to the 2/3 of other litigants who are potentially responsible parties who can drag in a utility or any other potentially responsible party under the 4 categories. So, you know, that doesn't work. And I also cited earlier, I don't know if you're in the room, but there's a case in New Jersey involving Passaic Valley Sewage District, and EPA actually brought them into litigation in the hope of giving them a get-out-of-jail-free card through a settlement. 10 years later, they're still in the litigation because of opposition from some of the major PRPs, and there's collateral litigation is run out of
Gentlewoman's
that.
time
So
has expired.
it's a sticky wicket, and quite frankly, no lawyer I talk to, and EPA, to their own credit, is just trying to do the best they can. So, but it's not a solution at all.
Thank you. I yield back. Thank you, Mr. Chair.